Good afternoon, everyone. My name is Nella Kelpick, and I'm the Outreach Director for Marsy's Law for Wisconsin. Thank you all for joining us as we mark National Crime Victims' Rights Week with today's roundtable discussion aimed at raising awareness about victims' constitutional and statutory rights. National Crime Victims' Rights Week this year falls at the same time we're celebrating the one-year anniversary of Marsy's Law passage in Wisconsin last April. As a survivor myself, it has been so heartening this past year to see Marsy's Law at work, helping crime victims navigate a criminal justice system they were forced into through no fault of their own. Most victims walk in with zero experience and have little or no understanding of the criminal justice system. Our conversation today will focus on crime victims' rights and will provide practical tips on how to break down barriers to accessing rights and demystifying the process. There will also be time for audience questions at the end, so please make sure you ask your questions using the chat feature. We're joined this afternoon by our wonderful panelists who graciously agreed to be part of this very important conversation. I want to now turn the conversation over to our moderator, Assistant Attorney General Miriam Falk, as trainer for sexual assault and domestic violence. She worked as an assistant district attorney in Milwaukee, assigned to the sensitive crime unit for the last 23 of her 27 years with the office. On a personal level, she has been an amazing resource to me over the last year. Miriam, the floor is yours.
Thanks, Nella. Hard to imagine that I'm only 30 years old, right? With all that experience under my belt. Welcome, everybody. I'm so glad that you are able to join us today. This is the second panel this week. Our first one was in Milwaukee, and people really did participate, asking a lot of questions. And so I encourage all of you to do that. Use the chat feature to do that, and we will get to as many questions as we are able to. I'd also ask that if you are a journalist, if you would include your name and the outlet for which you are working when you submit your question. That would be really helpful for us, and I appreciate that. As Nella has said, Marsy's Law has been around now for just about a year. It went into effect in May of 2020, and so we have been working with it to both empower victim voice and to enable the victim choice in the criminal justice system. And historically, that has not been a priority. And in fact, oftentimes it hasn't happened at all. The victim survivor who spoke on Monday in Milwaukee described that she often felt invisible in the process, which is something that, you know, all of us who are on this panel would really never want to see. And we're working hard now with the help of Marsy's Law to make sure that that never happens again to anybody. So with that, let me introduce our esteemed panel. I'm very excited today to introduce the four folks who are all different parts of our criminal justice system, who are going to be able to help answer your questions and give you some really good practical advice about your rights. Crystal Jensen is a practitioner in Eau Claire County and is originally from the Chippewa Valley region. For the last 5 years, she has worked in her capacity as one of our state's regional violence against women prosecutors, and she works in the northwest part of our state. She assists prosecutors, law enforcement, and advocates in the prosecution of sexual violence, intimate partner violence, stalking, and human trafficking. Prior to coming to Eau Claire, Ms. Jensen worked as a prosecutor in the Kenosha County DA's office and also in the La Crosse County DA's office. So she has a wide range of experience. I can also personally attest to the fact that Crystal is quite an expert in this area. She and I've been lucky enough, for me, to train together. And she is also, I think, one of our foremost state experts on the topic of strangulation. Our next individual on our panel is Bridget Coit. There's Ms. Coit right there. Bridget serves in the role of patrol sergeant since 2020. 14 years of law enforcement experience, 8 of which have been with the Eau Claire Police Department. During her tenure there, Sergeant Coit served as a patrol officer, a sensitive crimes investigator, and the public information officer. She is also a member of the crime scene unit, crisis negotiations team, and the police training officer program. Sergeant Coit has a master's degree in criminal justice from St. Cloud State University, and she and her husband, Casey, have 2 young children. I have 2 old children. So I tell you, enjoy them while they're young, although it's pretty fun when they get old too. So welcome to you, Bridget. Jessica is next. Jessica Bryan has been working with victims in some type of capacity since 2002. That's almost 20 years, Jessica. When she graduated from UW Stout with her bachelor's degree in human development and family studies. In 2010, she graduated with her master's in family studies and did her research on best practices of successful working collaboration with violence against women. Jessica has also been the victim witness coordinator and supervisor with Eau Claire County since 2013. Welcome, Jessica. And then finally, we have Mr. Bronson Stein. He is the legal advocate at Bolton Refuge House, Inc. in Eau Claire, Wisconsin. He is a second-generation victim advocate and strongly believes in the mission of ending violence against women and aiding all victims of crime. He serves on the Marsy's Law for Wisconsin Advisory Board and is the facilitator of the Eau Claire CCRT, which is a collaborative professional group designed to address the systemic response to intimate partner violence, domestic violence, and sexual assault. Welcome, Bronson. Thank you all for being here. All righty. I think we should start right off with some questions. I'm trying to keep a track of the time here, and we are right on time, so that's great. So Bronson, let's start with you. The first right that is identified in Marsy's Law is the right to be treated with dignity, respect, courtesy, sensitivity, and fairness. From my viewpoint, I think that this really is the primary right upon which all the rest of the rights flow. The primary objective of all the constitutional rights that are part of Marsy's Law is to foster a cultural climate of respect for victims, as opposed to adherence to any sort of biases or stereotypes. And so this elevation of victim rights to the level of constitutional rights so that they are equal to those of the offender, I think is a really, really important foundational principle. So working with victims now for as long as you have, Bronson, could you describe over the course of the time that you've been doing this work, what you see that has worked well for victims, and also areas where you have seen that there have been problems that hopefully Marsy's Law can help to correct?
Yeah, absolutely, I can. And I appreciate everything that you said, about those rights being the foundation upon which all the other rights flow from, right? The culture around victim services in Wisconsin has been one of development, moving it forward constantly. And with Marsy's Law, we see another iteration of that, that hopefully can bring about, a greater form of equity that we've been striving for quite some time. But as we all work within the system, we see often that things are working and things aren't working. And we need to continue to bring light and shine light on those things that aren't working. However, when it comes to things that are working, victims in at least Eau Claire have access to a victim's office through the DA's office, which is run by Jessica Bryan, the victim witness coordinator. They're very diligent. I think a lot of what works here in Eau Claire is the collaboration that we offer between victim services. Something that makes us unique is the amount of collaboration that we do, constantly meeting, talking about specific cases, getting release of information to discuss things, being with the victim and walking with the victim step by step. That's something that I've seen neglected in other counties, in my opinion, is a lack of general activity with the victim, especially when it comes to professionals, right? Offenders and other people in the criminal justice system are either trained or instructed or guided through the process. Victims need that same reassurance. Our prosecutors are very diligent in hearing from victims and addressing their concerns. I can't overstate how important this is when it comes to victim safety and even the success of prosecution. Victims are the experts, right? They're the experts on their lives. They've lived it. And when it comes to all of the elements that happen throughout the criminal justice process that we think about with offenders, victims experience those same things, right? Every bond modification, every bond or sentencing that happens, right? Plea deals. The victim is ultimately going to end up experiencing that the same as the offender, right? Whether or not the offender, goes away, right, gets put on probation. Those are all things that the victim needs to have an input in. And we're lucky, Claire, that our prosecutors work really hard and diligently to make sure that victims have a voice and that their concerns are addressed. When it comes to the issue of sensitivity, that's where sometimes we end up having kind of a little bit of a hit or miss situation. Victims that I've worked with are often, the actual charge being prosecuted represents a small fraction of the crimes they've actually experienced, right? The trauma that they've actually gone through. Typically, either they're isolated incidences that, there's enough evidence to charge out, right? But when we talk to the victim, there's usually a long history, especially in domestic violence, right, of years of abuse. Maybe the offender has been charged in the past as well against the same victim, but still that victim has been living in that world for a long time, and it's exhaustive, but more than that, it's traumatic, right, by its very nature. So when it comes to sensitivity, I've witnessed some court officials that have a tremendous amount of sensitivity for victims. The response is rooted in asking the victim how they feel about certain things, making sure that they are engaged with the process, making sure that they understand all the different elements. I've also experienced, court officials who completely dismiss a victim, right? Who tell that victim that their concerns either aren't valid or that, they would impede too much on the process. And that by its very nature leads to a lot of discretion by different court officials that leads to some instability for victims, when it comes to what to expect even. So here in Eau Claire County, like I said, we have a very diligent group of professionals who work together to try to increase victim access and increase kind of standardization of practices, but by no means are we perfect. And, we're always kind of gearing up for, the next fight and how to address the next situation. Something specifically when it comes to victims that I think gets overlooked in terms of sensitivity is that victims, didn't assume any risk, right? They didn't knowingly commit or violate any crimes, right? No statutes. They didn't, do anything to get them in that position. However, they are now being forced to endure that process, right? And if that process is not a trauma-informed process, then it is going to be traumatic for that victim. I mean, that's the nature of it. Being exposed, being outside of control of your own world, right? Having essentially court orders thrust upon you without much input, if that's the case. All of those things are oppressive to victims, right? And if they're not afforded those rights that we set from the beginning, right? Courtesy, dignity, respect, sensitivity, that process will be traumatic for them. And the fatigue that goes along with that is also, pretty intolerable for a lot of victims, right? Some of them, might not even look forward to the day that justice is granted. or found for them because they're just looking forward to the process getting done, right? And that's not a great place that I don't think anyone who gets into these lines of work wants victims to feel like, right? That they're just relieved that it's over. I think we all aim a little higher than that. But specifically when it comes to victims, what I've seen that hasn't worked quite well when it comes to sensitivity, I've just described all the things that I thought worked well, but something that doesn't work well is victims who are punished for not knowing or following decorum and procedure and all those other elements of the professional world that we've all been trained to do, right? Extensive training, a lot of training to get that knowledge kind of drilled in so we know exactly what to do. Victims, like I said before, are thrust into this, with mostly a very minimal lack or a minimal knowledge of what this is going to be, right? And even more so, as a victim advocate, a lot of what I experience is, meeting victims where they're at that moment, right? And what that means for us is that typically victims are not going to be cookie cutter, right? Some of them are going to be, use anger or, even frustration, right? As a form of communication. Something that professionals in this world have to learn very early on is that violence in families, if it's been going on long enough, it almost becomes a form of communication, right? And that anger that people feel, that frustration, power, and control, it can trickle even into victims, right? Victims can lash out, act in anger, act out in frustration. And part of sensitivity is understanding that, right? And trying to look for the root cause of that, especially if we're working within a system where the victim can be experiencing trauma from the system, right? Being ignored, being dismissed, all those different elements. A victim who is used to acting out in power and control because they've had to do that as a survival tactic. That's ultimately what it boils down to, is that if power and control violence becomes a way that people communicate within their families. We see it all the time, when kids are bullying in school, right? What's the first thing that any competent professional does, right? They look at home, right? They don't intrinsically believe that it's a problem with the child, right? They believe that it's something at home environmentally that's causing those kinds of issues, right? With victims, offenders, everyone. That's why we do the investigations that we do, right? PSIs and all that kind of stuff, is to try to find the root causes of why people do what they do, right? The sensitivity afforded to victims needs to hold that same kind of caliber of monitoring, right? We need to be able to see and really look for, why victims are doing what they're doing. And the reason for that is because I've seen victims completely dismissed because of their apparent frustration, right? With the system. I've seen victims who have been told by judges that their actions in the court, essentially gave grounds to believe the defense's argument that they were co-combatant, right? I've seen victims be threatened with contempt. I've seen victims who appeared to be apathetic and withdrawn. And all of those, from what we understand from every DV, training that anyone can take, you understand that, frustration, anger, being withdrawn, being apathetic, those are all symptoms of, PTSD or some other kind of trauma that a victim has experienced. And those symptoms can essentially lead you to believe that there's something deeper here. So how do I address that? Do I address that by threatening the victim? Right? That's not going to address it. Acting with compassion, acting with courtesy, acting with, sensitivity to the nature of, what the victim has been exposed to. Those are the kinds of ways in which the legal system will get a better sense of justice accomplished in the future than, continuing to threaten, right? And that's an area where, I've seen things not work out. When it comes to victims, a lot of times they've been surviving, right? Day to day to day to day, sometimes hour to hour, right? Walking on eggshells, feeling out of control in their own homes, feeling constant fear, pressure. Those are really strong emotions to just come out of, right? You get, a sense of normalcy in that environment. Maybe, the prosecutor puts on a no contact, and now you have, almost free reign to start feeling some kind of peace. But the way that you've been feeling in the past is still going to start exposing itself, right? It's still going to rear its head. Those behaviors don't go away, especially when we've used them so diligently to protect ourselves. And now we're being exposed to a system that is prodding, right? It's poking, we're being investigated. Maybe we have children with the offender and we're starting to believe that, people are looking at that, right? We're feeling attacked. It's normal for us to look back on those survival skills we've used and try to, find our power and control within those survival skills. And that's why, having an educated, criminal justice system that understands those things is critical. Because if, like I said before, I've seen it where they don't understand those things. And the victim is ultimately the one who suffers from that. Typically, in my world specifically, dealing with victims of domestic violence, sexual assault, stalking, the whole gamut of IPV, intimate partner violence, when it comes to victims are typically more raw, a little bit more honest, right, about how they're feeling, whether they're upset. Offenders are typically, abusers, given kind of the manipulation that we know happens in power and control dynamics, they're typically a little bit more refined, right? And they can look compliant, right? They put on a dress shirt, right? They sit there quietly while their attorney talks for them. It's a totally different game. And victims shouldn't have to explain to us professionals why they are the way they are, right? We should already understand that. We should know those things. We should be able to look for them. We shouldn't have to be instructed by victims about why they might be upset, right? Why they might have concerns. We're human beings. We understand. If we just, have the common sense approach, why someone would be, a little more angry or aggressive, right? When it comes to that. So, the last little bit, when it comes to this, things that didn't work, I believe that sensitivity, courtesy, all those things just boil down back to having empathy, right? Being able to view a victim as a person and truly understanding that they are the experts, right? We have all the training, we have the tools, we have the power and the platform. That is what these titles in this position offers us. But as far as the fundamental drive for victims, when it comes to what doesn't work, it all falls back to having a lack of empathy, right? Not thinking about what my decision is going to cause that victim, right? And ultimately that victim is going to live that experience. Again, victims are the ones who experience the sentencing, the deals, all that, just as much as the offender. They deserve kind of the basic fundamental rights that will get them the protections they need to actively advocate for themselves, right? That's ultimately what it boils down to. So I appreciate being able to explain that.
Thank you, Branson. That was very comprehensive.
Yeah, that was a lot. So.
I really appreciate that. And I think that, really bringing it down to understanding trauma, that is something that I think within the last maybe decade or so has become something that is much more on the front burner, but also approaching the victims with the empathy that they deserve, really understanding the challenges of their position. All right, I'm going to turn to Jessica. as Bronson has said, the criminal justice system can be overwhelming and confusing even on the very best of days. And as Nella said, most people who engage in it as a crime victim don't know much, if anything, about the system or the way things operate or what their rights are. And we know that Marsy's Law's goal is to empower victim voices and choices by providing notification of rights, notification of proceedings, the opportunity to be heard at proceedings, and also a chance to talk with the attorney for the government. As an advocate who works with victims, can you describe for us more about how victims learn about their rights and who helps them to exercise them when they choose to do that?
Sure. We are very fortunate here in Eau Claire, where we have a crisis response team program that is connected to our Victim Witness Services office. And so what that means for us is that a lot of times our victims are getting that immediate service, being notified of rights immediately right at the time or right after the time of the crime that occurred. And how that happens is that our partnership with law enforcement, they call us out, meaning the crisis response specialists and volunteers on scene, as long as it's safe for everybody, to provide services immediately to victims. And when I am talking about crime victims, I'm talking about all crime victims. We provide services to victims of forgery, your hit and run, your property crimes, your domestics, your sexual assaults, stalking, any type of crime that has a victim, we provide services to. And so our crisis response is trained to provide those services, making sure victims are afforded any resources that they may need right there at that immediate time of the crisis. And then what happens is once the referral is made to the DA's office, that's when victim witness gets involved. So they literally transition from a crisis response specialist to a victim witness specialist. And so they are never left alone as far as not having someone assigned to them during the criminal court process. The victim witness specialist, crisis response specialist, we contact the victims immediately before there's a court hearing. Usually we call it's our initial appearance court hearing. It happens Monday through Friday at 11 a.m. Anybody who had any victim of a crime, like the night before, the weekend before, they are being notified before 11 o'clock court every day, Monday through Friday, being notified that this court hearing is going to be happening. They're being asked what they would like to see as far as bond conditions. They're asked, making sure that this time for the hearing works for them. Do they want to participate in the hearing? And from that hearing on moving on forward, if they want to participate in every court hearing, they have a right to do that. And that's when they're made known of that right. So crisis response, victim witness services, we make them aware of their rights. We notify them of all court hearings. And I would say with Marsy's Law, one thing that's really changed in our service providing is that we are really having more direct client contact, victim contact. In the past, a lot of it was done through letters and mail, where now I feel like we are picking up the phone more. We're talking to our victims more through the phone, communicating through email. So we have that instant connection. They're getting that instant response, and in person. So I really feel like it's humanizing our process by having that direct client contact rather than just a letter in the mail, not knowing whether a victim read it, not knowing if they understand their rights. So that is something that I feel like Marsy's Law has really changed in our area for us. We are with them throughout the whole court process. We are there to help them confer with the prosecutor if that's something they want to do. If they want to confer with the prosecutor more than once, we will make that happen for them. We will be that person to set up that phone call or that direct meeting with the prosecutor, explaining why things are happening the way they are. A lot of times, I shouldn't say a lot of times, but it does happen a lot of times, the victim may not be happy with the outcome of the case. They might not understand why a prosecutor is making a decision that they're making. And it's our job to make sure that the prosecutor can help explain that to the victim, that, this is why I'm making this decision. I hear what you have to say. I'm taking that into consideration, but this is what I have to do. We always had a prosecutor in our office say that they had the best job in the world because all they had to do was do what was right. But sometimes doing what is right is not always the most pleasing response or pleasing decision in a case. And so it's really having that victim, helping that victim have their voice to be able to be heard by the judges, the prosecution, at their victim impact statements at the time of plea and sentencing, that they're being heard, that, that a judge is taking into consideration what they have to say. And so really we are their voice. Once the criminal process is over, and even during it, we want to make sure that they are reaching out to extend services, whether it's advocates at Bolton, maybe it's someone with aging and disability services, maybe it's someone that needs to be set up with someone who's going to be able to help them with any kind of financial resources they may need. We want to make sure that they're prepared that once the criminal justice system is over, they still have the support and continued services that they need.
Thank you, Jessica. Thank you very much. I appreciate, a couple of things that you said. One of them being that there are people in the system whose primary function within the system is to be there to help the victim, to walk through from beginning to end. And there are actually two different ways that people can access that kind of help. One is through community services like yours, which also carries with it then that confidentiality that I think can be very important to people who, might be going through something that is very private or very painful or traumatic, and they need somebody that they can speak with, extremely freely, knowing that whatever is said is confidential. For instance, the domestic violence victim or the sexual assault victim. That's a really important aspect. And then, of course, the other piece of advocacy is within the district attorney's office itself. Those advocates who can really, in addition to anybody in the community who's helping them, can also help them really connect and engage directly with the court and with the prosecutor. And I think that, for people to understand that those folks, both in the community and in the DA's office, their whole job is to try to make this journey for the victim something that is as untraumatic as possible, an opportunity to, keep empowering the victim and keeping that victim voice heard, I think is a really important job. And of course, for community advocates as well, for many people, those needs don't stop at the end of the criminal case, right? And it continues to go on even in the future. So that's also something that is available for victims. And there's a lot to know, right? I mean, there's just really a lot for victims to know. I'm going to turn to Bridget for this next question, because I think it really kind of relates to some of the things that you've talked about, Jessica. Often, in fact, usually I would say it is a police officer who has the first contacts with a crime victim. And we heard from Jessica about how law enforcement engages advocacy right away, and that's an excellent thing. And I know that it happens in Oakland County. And so it is law enforcement then who is providing and is required under Marsy's law and also under our statutory scheme to provide notification to a victim of what those rights are. One particular concern for most victims is their safety. And of course, one specific right in Marsy's law is the right to reasonable protection from the accused throughout the criminal justice process. So Bridget, can you help us understand how law enforcement works with victims to help ensure that the victims are receiving reasonable protection from the accused throughout the process?
Absolutely. Thank you, Miriam, and thank you everybody for the input that you have provided. I entered law enforcement because I wanted to be the first person there to help victims, especially victims of domestic violence and sexual assault and children. And I know the vast majority of my partners entered law enforcement for the same reason. And so when we come to a incident of domestic violence and or sexual assault, our large goal is to find out what happened in that incident and to make sure that that victim is safe, and to investigate that incident properly. And I think we're definitely trying to get better about trauma-informed care. and being empathetic with the victim, and not only finding out about that specific incident, but really trying to expand our knowledge as to what that domestic relationship or I guess relationship in general has entailed, and the ongoing abuse that that victim has sustained. Understanding that we're only getting a snapshot of that incident when we respond, but that there's so much that has likely occurred before that that we need to understand. And one of the ways that we do that is through the lethality assessment program. Within the last 3 years, we have implemented the lethality assessment form to go over with our victims. Some of those questions on those forms are, has he or she ever used a weapon against you to threaten you? Has he or she ever tried to choke you? Does he or she ever try to constantly control your daily activities or is jealous? Are they unemployed? And basic kind of understanding of that relationship. And that form really helps us guide what that safety level is and what that risk is for not only just in that moment, but the continuation of, or I should say, the length of that relationship to help ensure and guide the victim best going forward for their safety. At the end of that lethality assessment form, we contact our advocates through the Bolton Refuge House and immediately try to engage a victim with that advocate for their safety. So and then they help guide whether or not is it safe for them to stay in their residence for that night. And do they have another family member or friend that they can go to for the short term, at least until the court can implement some, no contact provisions or bond conditions, or whether or not that person will remain in custody so that that victim feels safe. In addition, throughout the kind of criminal proceedings, the judge likely has implemented bond conditions to have no contact. And if we find out about that no contact through the victim or through the advocates, additional legal action is taken and criminal charges. And there is statutes in place to protect, threatening or intimidation of a victim or witness. So I think essentially those laws are in place and, those bond conditions are in place and no contacts or potentially restraining orders are in place, but getting the victim advocates up front for that victim and for that support so that not only we as law enforcement can focus on directly what occurred during that incident and what the appropriate arrest decision may be, but having a broader understanding of that relationship in general and what that safety risk is. And the more that we learn from that victim who is in control of that situation, the more they can help guide us to help keep them safe.
Thank you, Bridget. I appreciate that. And I think that you have also hit on the whole idea of bail and the conditions of bail. And of course that, that piece that in part of the investigation, finding out about those particular things that might be risk factors with an offender and communicating that to prosecutors who can then make specific requests for conditions of bail. And I know also that when there are violations of those conditions, we know that law enforcement is going to be jumping on that right away and referring cases to the prosecution for additional charges like bail jumping or violations of restraining order or even intimidation of a victim or a witness. So I really appreciate it. All of those things, again, I think underscore the importance of the collaboration between all of us that is, I think, highlighted by Marsy's law in particular. Well, let's turn to our prosecutor, Crystal, here. Another very common set of concerns for many victims is getting restitution to compensate for their losses. And that can be, psychological treatment that they've gotten. It could be for property losses. There's a whole wide range of things that people can lose as a result of a crime. In addition, I think it's also important for victims to be able to inform the court about how they have been impacted by the crime against them. And under Marsy's law, we know that victims have a right to confer with the attorney for the government and to have information about the physical, psychological, and economic impact of the crime provided to the court, as well as to full restitution and assistance in collecting it. Now, I know that restitution is typically determined at the time of sentencing after an accused has been convicted of a crime, either because they pled or because there's been a trial and a guilty verdict. So, Crystal, if you could maybe explain for us more what a victim can receive as part of restitution, and what are the ways that a victim can work with the prosecutor or more generally on the issue of restitution.
Okay, well, thank you, Miriam. So restitution really, a couple ways to look at it is part of trying to make the victim whole again in the criminal justice system. And it's through the financial impact that we try to make the victim whole. So there are a couple of different components to that. One is your basic impact or loss from the incident or crime itself. For example, damaged property, medical bills if the person had to seek treatment after the incident or assault. There can be restitution for lost wages or for participating in the process. One of the victims have to or can sometimes go through a lot in just participating in the criminal justice system, taking time away from work, trying to secure childcare. So restitution is one of those things that we try to make available for victims. So if you're talking to the investigator or talking to the prosecutor, you should be able to recoup some of that loss. There's also then the counseling and ongoing harm that the crime can cause for a victim. And that is something that we try to collect. One important thing with restitution is that it is not punitive. I think sometimes there's some confusion with victims where they treat it almost like a lawsuit, where they want to be made whole financially, not just for what they lost physically and emotionally, but want to be able to punish or collect a cost for what that offender has done to them. That's something that we cannot collect for, and that's often part of the ongoing conversation. Victim witness is critical in the restitution aspect. They're the ones that do all the legwork for prosecutors. They're the ones sending out the notice, having victims send in documentation. So as part of the question of what do victims have to do or how can they participate in restitution, it's documenting what was lost. Sometimes we have to go and get receipts. We have to get verification for employers for the actual lost hours. We have to get verification through of medical bills and that type of thing. So it is really just, unfortunately, with much of the system, it's practice and patience for victims and having to get that all together and getting that provided to the district attorney's office. For the things that victims qualify for, we will ask for that full amount to the judge. And then sometimes there is further discussion and further litigation as to what that final amount will be. But if it's legitimate and request and should be a request under the law, the district attorney's office makes that request of the victim.
All right, thank you. So generally speaking, then it is the prosecutor who's going to be putting forth the restitution requests of the victim at the sentencing, and I appreciate that. You know, as a prosecutor myself, I know that, the last thing that you want to have happen is for a defendant to challenge the amount and you don't have any of that documentation. So on behalf of the victims and prosecutors everywhere, I really appreciate the legwork that's done by law enforcement and our advocacy to start right away, helping victims collect that documentation, keep the records, collecting the records in one secure place, because that's oftentimes about the last thing that victims really want to have to do right after they've had some sort of very traumatic incident happen to them. So I appreciate that. Our last question, and I've been checking the chat box and we don't have any questions yet. So I really want to encourage people, if you do have questions, to put those in the chat box, because we will definitely have some time to respond to questions. So our last particular question here relates to what I think is a very important right of the victims. It's the second one after the right to being treated with dignity, respect, courtesy, sensitivity, and fairness. And this is the right to privacy. Wisconsin stands alone in the United States. Among all the states who have already enacted Marsy's Law, we are the only state that enacted Marsy's Law with a standalone right to privacy. And what privacy is not defined, and that's on purpose, because what we've learned is that what is considered private by one person is not necessarily the same as what another person might think. And we've learned, as we have implemented Marsy's Law for the last year, how important it is for us to be checking in with each victim to find out what may or may not be significant in terms of their privacy for them. And I am proud of Wisconsin. We have been a leader in terms of victims' rights legislation and victims' rights actions for many, many decades now, starting back in the 70s when Milwaukee became one of the first two places in the United States to actually have an embedded victim witness program right in the DA's office. So yay for us, right? Yay for Wisconsin. So since privacy is different from one person to another, and since it can change, it can morph, you can feel one way at the very beginning, and later on, other things become really important. This ongoing conversation is really important. And I wanted to just give a couple ideas and then open it up to the panel to see what other ideas they have here. One of the things that I know is happening throughout the state, and I believe particularly in Eau Claire, is trying to maintain victim anonymity to the extent possible, using initials or even pseudonyms like Victim One or Jane Doe in our publicly filed reports and complaints and other documents in court to maintain victim privacy in that way. We also pursue protective orders. So when we are dealing with private information like a victim's social security number or their address or their email address, we are working hard to make sure that that information does not get out into the general public. And we ask the court even to make sure to establish some other parameters around who can share that information and under what circumstances and when it has to get turned back to the court. Courts have the ability to seal records. So let's say that your medical records become important because you were physically injured. You can be assured that that's not going to be out there for everybody to see, because the court has the power to seal records and to extract from documents that might contain private information that has nothing to do with the case. Nobody will see that at all. And then, of course, we also have the ability to limit the amount of information that might get out to the public through open records requests as well, understanding that that confidentiality is really important. There is one question in the chat, but before we turn to that, I just wanted to check with the panel and see if there are any other points that you wanted to make about privacy or any of the other issues that have been raised. Jessica?
I was going to say one program partner that we have that's wonderful is Judicare. Within our criminal process, so many times our prosecutors, they're focused on that criminal case. And a lot of times within criminal cases, a lot of privacy issues for the victim do come up. And Judicare is something that we've really been utilizing a lot in Eau Claire County. What it is it's a free legal service for our victims. So they actually are represented by their own attorney through Judicare. And then Judicare can focus on the privacy issues. They can assist our prosecutors with motions, with getting things sealed. And so that has been a wonderful project partner for us in Eau Claire is Judicare, having our victims have their own representation, someone that actually represents just them and really focuses on their privacy. So we have been very lucky and fortunate to have that program.
Thanks, Jessica. Any other comments, generally speaking, before we get to the questions in the chat? Okay, so one of the questions, and I'm going to just answer this one right off the bat here, is does Marsy's law constitute all brand spanking new rights here in Wisconsin, or have some of these existed already? And the answer to that is some are new and some are not. Very lawyerly answer, I think, right? So before Marsy's law, we had a statutory victims' rights, which still exist under Chapter 950. That's the victims' statutory rights. And in the past, we've also had a constitutional amendment. The difference between the past constitutional amendment and Marsy's law is that the past constitutional amendment required additional legislation in order for those provisions to become enforceable as law. And we waited many years actually for that to happen. Marsy's law was self-executing, and that means that as soon as it actually became law in May of 2020, those were now the constitutional rights of the victim. The other difference between Chapter 950 and Marsy's law that is significant is the difference between statutory rights and constitutional rights. Constitutional rights have more weight in the system, in the criminal justice system. And so the impact of Marsy's law is to elevate the rights of the victim to be equal to those of the defendant, not greater than those of the defendant, but equal to the rights of the criminal defendant. And there are some new provisions in Marsy's law that did not exist before. And I can't enumerate them for you right now, but there are some new things. So if you compared Chapter 950 to Marsy's law, you would be able to see what those are. Did anybody else want to add to that? People are shaking their heads already. Another question we have is whether we have seen changes in prosecution success when you have domestic violence who want to voice their opinion that the person should not be charged or should not have cash bond, or does not want a no contact order, or any other comments made during the criminal court process. So maybe Crystal, if you could address that a little bit. What have you seen? And then maybe Bronson, you might want to add into that too.
Well, success in domestic violence prosecution oftentimes is very different than what success means in other prosecution of other crimes. And I think the question highlights the fact that with domestic violence cases, oftentimes the victim may not be in a position to fully engage or participate in the system for safety concerns, for concerns and care for the offender and abuser. As far as what Marsy's law has changed or not changed, from my personal practice previously, even if a victim disagreed with the prosecution or the bail or no contact provisions, I would still and have always been willing to meet and speak with the victim on those particular issues and try to at least we get to a point of may not agree with the decision-making on the case, but at least the victim can understand what that decision-making or the reasons behind that decision making. So I can't say a whole lot has changed for my own personal practice. We also implemented Marsy's law through the haze of COVID restrictions. So I think in the next year, we'll probably see what that looks like a little bit more as we're returning more into face-to-face interactions and kind of returning more to whatever the new normal is.
Thanks, Crystal. Jessica or Bronson?
Yeah, I would I would agree with everything that Crystal said and just add that emotionally successful when it comes to a victim's access, their right to be heard, right? Having a voice, feeling valued in the process is critical to their feelings regarding the outcome, right? Like Crystal said, they might not agree, and ultimately the state, isn't representing the victim, right? They're representing the state. So the victim's opinions may not reflect what the state ultimately decides to do. However, giving that victim, and not giving that, but validating the right that that victim has the right to feel the way that they feel, right, is critical to a successful prosecution, right? As I stated in the beginning, the victim is the one who ultimately has to live with the recommendation, right? The rest of us, we go on to our other cases, right? We move on, in our professional lives and our personal lives, whatever. At the end of the day, a victim is the one experiencing those things as well. So their right to be heard and validated, and the resources that Crystal and Jessica utilize in the prosecution to make sure that happens is integral to success, in my opinion, as a legal advocate.
Yeah, I'd have to agree with that also. I think that, one of the things that we know, just even from research, is that people who feel heard are much more satisfied. And sometimes things don't, we don't control everything. None of us do. And so, but I think that what's important is that you feel heard and that you feel believed and that you feel appreciated and respected, even if everything doesn't totally work out the way that you want to. And I guess the other thing I should say is that, the criminal justice system can never make any victim completely whole again. And so, but we can get a measure of justice and we can hold people accountable. And I think that that's a really important part of the system that we all can work with. One of the questions that came through was about whether we as a group feel that Marsy's Law has helped in any way in making victims feel more comfortable navigating through the system. So Jessica, I'm going to toss that to you a little bit and then maybe see, Bridget, if you have anything you want to add.
I'm hoping so. Like I talked about earlier, for our office, we're doing a lot more telephone calls, meeting in person, that direct client contact rather than mail. And so I think we're able to answer a lot more questions in a timely fashion, in a quicker fashion for victims. And then one thing within the criminal justice system is there's constantly changing of hearings. And so now we are constantly on the phone calling that victim saying, hey, today's hearing is coming off. Like, we were just notified, today's hearing's coming off. It's now going to be postponed to this date, or maybe it's going to be earlier. So we just really are having more of that direct client contact that I hope is helping victims navigate the system smoothlier.
Mm-hmm. Bridget, did you want to add to that?
Yeah, I think the only thing that I would add is that, we're not getting a lot of victims out there, that specifically reference Marsy's Law. But we are seeing we're doing a better job of just implementing the practices that go along with Marsy's Law. So the reference to the legality assessment form and the practices and connecting them with an advocate and that trauma-informed care and that empathy and respect, I think is definitely improving, and we hope to improve further on those practices that Marsy's Law helps implement.
Richard, I agree with you on that too. I think that, it's less important really what we call any of this, but really more important how we're actually as a system implementing it. And the fact that Marsy's Law has opened up all of these conversations and even has, I think, welcomed in victims and made them feel like they can say, hey, what about me? Or what about this? Is really important, that this is now on the front burner for all of us. I can anecdotally say that, years ago, when I was really young, we would schedule court hearings and then we would call the victim and say, hey, so here's the court hearing. And if it was their birthday or their wedding anniversary or their high school final or their college graduation, too bad, so sad, right? And that has really changed. And that's just one example of, I think, the way that we really moved toward putting victim rights on a much more even playing field with everybody else. It's not an afterthought anymore. It really is a central feature of our criminal justice response. Let me check the time here. We've got 1 minute left. I don't see any more questions in the chat. There was one about how to get regular people language about Marsy's Law, and I have answered that in the chat, but I will say to everybody that you can go to marsyslawwisconsin.com. And also you can check the Wisconsin Department of Justice Office of Crime Victim Services website. So that's the Wisconsin Department of Justice Office of Crime Victim Services, and you'll be able to find out more about Marsy's Law. And I honestly, if you Google Marsy's Law Wisconsin, things will open up on your Google, as I would say, because I'm an old person. All right. I want to thank you all you panelists. Thank you so much for an excellent discussion today. I hope that all of you out there who are listening have feel like you've gotten a little better grasp about what victims' rights are and how victims can implement them. And with that, I'm going to turn it over back to Nella.
Well, thank you, Miriam, and thank you again to all the panelists. Such great conversation. And on behalf of Marsy's Law for Wisconsin, I want to thank everyone for attending today's event. Have a wonderful day.